Mic test 1 2 1 2 1 2 1 2 1 2 1 2. It's fine. 1 2 1 2 1 2. Perfect.
Commissioners are entering, please rise.
Good morning. Today we are going to hear the opening statements of the parties. And the first person to start will be Ms. Ndlogo for the NPA. Ms. Ndlogo, how long are you going to require?
Good morning, Commissioner. As things stand, we would require 30 minutes.
30 minutes?
Correct.
Yes. You may commence, ma'am.
Thank you. If I may be given just a minute, I had initially thought that what was sent to us was the Commission and then the NPA. I just need to pull it out.
Your voice is indistinct. If you've started speaking, can you pull the mic closer?
My apologies. I was saying if I could given a minute, I need to pull out the statement. I had initially thought that what we were sent, which is the Commission starts and then we come right after them.
Yes. Ms. Ntloko is about to commence, is it not so, Ms. Ntloko? Or should we pass you?
Madam Commissioner, if Mr. Nell is ready to begin, I would be happy for him to.
Yes.
Because I'm trying to download this and the
Yes.
network here is rather slow.
Yes. Mr. Nell?
Yes. Thank you very much. I'm indeed ready to proceed.
Yes. How many minutes are you going to require?
15 to 20.
Thank you.
I'm sure it's 15, but I'll give myself 20.
Thank you.
Thank you very much. My colleague, Advocate Phyllis Foster, and I, we represent the witnesses, Carl Martin Creel, Jacob Gabriel Celia van der Merwe, and Mr. Andrew Gordon Leesk. We do so on instruction of Hurton and Spies attorneys. Dealing with Mr. van der Merwe, Mr. van der Merwe's evidence will focus on the failure to investigate and prosecute the suspects in the murder of his father, Jacob Gabriel van der Merwe, who was shot and killed on the 1st of November 1978. The suspect, who were clearly identified and known to the South African Police Service since December 1981, have never applied for amnesty, and the failure to prosecute the case has allowed at least one of the suspects the opportunity to build a career in the current government structures. It's worth mentioning, and we'll pursue that although it appears from an analysis of social media that the suspect is known to the head of the missing persons task team in the MPA, the body of the deceased has never been recovered. Mr. van der Merwe's mother, who testified before the TRC, passed away without the privilege of burying her husband. We will argue that the only reasonable inference is that the failure to prosecute was intentional. We hope to pursue what we have been told are the expressed views of members of the NPA that they will not pursue members of MK who fail to apply for or obtain amnesty. Van der Merwe's evidence and that of Mr. Creel will implore the Commission to ensure that the principle of equality before the law is restored by focusing not only on the failure to prosecute members of the armed forces, but also on all those who have failed to apply for or obtain amnesty, and that includes the so-called ANC 37. Contrary to previous uninformed arguments before this Commission, we hold no brief for anyone who have made themselves guilty of crimes and has not obtained amnesty. We do not act for any implicated member of the former security forces. Mr. Creel is the Chief Executive Officer of AfriForum, a non-profit civil rights organization with approximately 300,000 members. His evidence will focus on the principle of equality before the law, with an underlying plea to all parties to close the book of the past. This has been his and AfriForum's views since 2007, when he wrote a letter expressing his views to the then President Mbeki. Mr. Creel's evidence is relevant because it focuses on individuals who have either committed or ordered crimes, and the implicated individuals who were either unable to meet the requirements for amnesty or did not apply for amnesty at all. These individuals are known, and the failure to properly investigate and prosecute them is deliberate and inexplicable. We will represent Mr. Andrew Leesk, a former chief investigator of the Directorate of Special Operations, the DSO Scorpions, as they were known, should the evidence leaders or any other party decide that his evidence is relevant and that he should testify. We have applied to the chairperson of the Commission to exercise her discretion in terms of provisions of Section 7 of the rules to call Mr. Creel and Mr. van der Merwe as witnesses. We have, as was required, filed the affidavits, submitted the affidavits to the Commission in November 2025, and they've been available since then. Our application under Section 31 of the rules will be formalized, that is to lead the evidence of our own witnesses, once we receive notice that our witnesses will be required to testify. That, Madam Chair, is my opening address.
Thank you, Mr. Nell. Ms. Ntloko?
Thank you, Madam Chair. And thank you for that indulgence. Together with my senior, Gwala SC, we appear for the National Prosecuting Authority. He sends his apologies. He is running a trial in the Eastern Cape. The National Prosecuting Authority appears before this commission as a constitutional institution established under Section 179 of the Constitution, entrusted with the power and duty to institute criminal proceedings without fear, favor, or prejudice. The NPA recognizes that the effectiveness of this commission's mandate depends on a careful, fair, and constitutional grounded examination of prosecutorial decision-making within its proper and institutional context. The National Prosecuting Authority further appears before this commission in response to the serious allegations that are the subject matter of its mandate. It does so with the full appreciation of the gravity of the matters under inquiry, the profound public interest they engage, and the enduring significance of accountability for crimes arising out of South Africa's past. The NPA recognizes that crimes arising from the TRC matters occupy a unique and sensitive place in South Africa's constitutional landscape. They engage not only questions of criminal accountability, but also the unfinished business of historical injustices, the dignity of victims and survivors, and the integrity of the constitutional promise that gross violations of human rights will not be met with impunity. These matters are inextricably linked to South Africa's democratic transition and the state's obligation, both in domestic and international law, to investigate, prosecute, and remedy serious violations of fundamental rights. How they are approached has profound implications for societal healing, public confidence in the justice system, and the credibility of constitutional institutions entrusted with giving practical effect to the values of accountability, responsiveness, and openness. At the heart of it, therefore, the NPA supports the Commission's work and is of the view that the work must strike a careful and principled balance. It must advance the imperative of truth-seeking and accountability in a manner that is consistent with the constitutional guarantees, respects the separation of powers, and preserves the independence of prosecutorial and investigative institutions. In this context, the NPA's engagement in this commission will be guided by its constitutional mandate to act without fear, favor, or prejudice. Following this brief introduction, the NPA will address the following in the structured manner. This is the roadmap. We'll first deal with the terms of reference that we've been called here for. Secondly, the NPA will deal with its constitutional mandate very briefly, and then we'll provide the essential context of what the evidence that they've put before this commission will indicate, and then clarify the position in relation to the former national directors and public prosecutors. As the commission will know, the NPA has been divided into two teams, with the current leadership being represented by myself and Gwala, and the former NDPPs and other public prosecutors being represented by various law firms and advocates. And finally, the NPA will conclude with brief remarks directed at the proper framing of the Commission's tasks. Briefly, to deal with the terms of reference. What we understand the terms of reference to be is that the Commission is temporarily confined to the period from 2003 onwards and is substantively directed to determine the following: whether, by whom, and to what extent or attempts were made to influence or pressure members of the SAPS or the NPA to halt the investigation or prosecution of TRC-related matters; whether any members of the SAPS or the NPA improperly colluded or succumbed to such pressure; whether unlawful conduct occurred warranting further investigations or prosecutions by appropriate authorities, and whether, in terms of the law and fairness, the payment of constitutional damages to affected parties appropriate. And in light with the scope of this mandate, the Commission is carefully delineated. It is directed at specific allegations of alleged interference, pressure, collusion, or unlawful influence. And it will be, the NPA will be attending only to that which is within this mandate. And I'll move shortly to the NPA's mandate and the role in this constitutional democracy. As we all know and can appreciate, South Africa's constitutional democracy was not gifted. It was forged through systematic violence, repression, and the deliberate dehumanization of mostly Black South Africans and South Africans as a whole, whose lives, liberty, and dignity were routinely extinguished in service of an unjust political order. Countless men and women were detained, tortured, disappeared, and killed. Many died unnamed, unrecorded. Their families denied both truth and justice. Their blood was shed, and this is probably why we are here today. So it is against this historical background that the obligation to investigate and prosecute apartheid-era crimes must be understood. These are not ordinary crimes. They represent the most serious violations of human rights, committed with the authority of the state and often shielded the then state by it. Accountability for such crimes, while not discretionary, needs to be dealt with in a constitutional manner. For this reason, the Constitution vests the power to institute criminal proceedings exclusively to the NPA. That power is exercised on behalf of the people of South Africa, not private interests, not political actors, and not sectional agendas. It is entrusted to a single independent prosecuting authority precisely because history has taught us the catastrophic consequences that follow when prosecutorial powers is fragmented and given to private entities. And therefore, the National Prosecuting Authority will at all times be acting within its mandate and has been acting within its mandate under Section 179 of the Constitution. In order to curtail time, we will upload the rest of the opening statement, but I will now move briefly to deal with the evidence that will be placed before this commission by the NPA. The evidence that will be placed by the National Prosecuting Authority will demonstrate that there has been a sustained, structured, and constitutionally compliant effort to investigate and prosecute matters emanating from the TRC, particularly over the past decade. And at this instance, I wish to point out that the NPA has not and does not accept or reject that there has been political interference in the investigation of prosecutions of TRC-related matters. That is still a matter to be determined based on the evidence that will come up. And therefore, there is no concession or denial in that regard. At the same time, the current leadership, and I say current because of the delineations of what has indicated earlier about who represents who within the bigger scheme of the NPA, has no direct knowledge of any political interference, pressure, or collusion in relation to the TRC cases during its tenure. And when I say current, I also mean just the former at this particular point in time. As we are aware, there's a new NDPP. The evidence that will be placed before the Commission, therefore, by the NPA will therefore be confined to matters within its institutional knowledge, records, and experiences, particularly over the past 6 years. That evidence will demonstrate how prosecutorial decisions were made during this period, the safeguards that were in place, and the absence of any improper influence on those decisions. And we wish to point out where courts have previously made any findings in relation to TRC matters, those findings shall speak for themselves. The NPA shall not seek to review them in these proceedings, nor seek to go back and forth in relation to therein. The evidence will demonstrate further that since 2019, which is when the former NDPP to date, the NPA has undertaken deliberate, structured, and sustained measures to address matters emanating from the TRC processes. Within the confines of the Constitution, the NPA Act, binding policies, and budgets. First, the evidence will show that while we can accept that there has been some delay in certain matters, those have not been deliberate. There has been issues in relation to resources, and as we know, we are in South Africa, the coffers are not deep, and therefore it's not just a money issue, there is also a human resource aspect. Second, the evidence will show that TRC cases present unique and exceptional prosecutorial difficulties. These matters concerns crimes committed several decades ago, frequently in circumstances marked by deliberate concealment, destruction of records, and systematic obstruction, and not by the current government. In many instances, original police dockets, inquest records, post-mortem reports, and forensic exhibits were destroyed, lost, or never properly created. Witnesses and suspects have aged, relocated, or passed away. In some matters, even the basic factual building blocks still require investigation. Dates, location, identities, causes of death are incomplete or contested. The evidence will show that these realities impose severe evidentiary limitation that no prosecuting authority acting lawfully reasonable can simply overcome by mere luck. And thirdly, the evidence will demonstrate the challenges over the years as the Commission will understand as the evidence is given. The NPA does not act on its own. There are other players, including the SAPS, the DPCI, and therefore there has been issues therein in relation to investigations as well. And we will delve more when the witnesses are put on the stand on what it takes to, in fact, go through a successful prosecution. And finally, the evidence will also show that there has been a commitment on the NPA to prosecute these matters, and further show that the NPA did not treat victim engagement as a peripheral issue. The evidence will show that there's been regular engagements which have been held with families, civil societies, and legal representations. Prosecutors and investigators have been directed to communicate progress, explain delays, and account for decisions, and this has been done. And therefore, while the allegations of political interference may not be ignored, they will need to be addressed within a context. What was the decision? What was the rationale behind any particular decision? Because as we all know, a decision on its own does not in its own mean that there is interference. And because of that, we will show that there has been matters that have progressed far beyond what may be believed in the public eye. We'll show that matters presently on the crime court's roll include the causes for prosecution, the similar prosecutions where intellectual issues such as the Section 77.3 processes have delayed finalization. And we will also show that there has been other matters that have equally been progressed. And such matters, beyond the matters that we are dealing with in this particular commission that have been highlighted by what we have come to know as the Tsalata Group, particular inquests into the death of Stephen Bandubiko have been opened. The reopening of the inquest of the death of Mr. Griffiths Mlenge has equally been opened. And others like Mzwandile Mveya, Sandiso Yeso, Samora Mpendulo, Sadat Mpendulo, and Tando Mtembu have been reopened, but these are just a few. I wish to highlight at this point that there are certain matters that we cannot divulge at this commission because the sensitivities around the investigations are quite high, and therefore to deal and to enter the fray in those matters might in actual fact do harm rather than good. And then just to deal briefly with the position of former NDPPs, because you have heard me saying the current NPA, the current NPA. The former NDPPs and DPPs and other officials of the NPA are legally represented. So the commission will get a full account from 2000 all the way to currently, but every single NDPP will be doing that for its tenure. And we can appreciate, while an institutional account is required, institutions do not run themselves. And because of that, there is particular knowledge that particular NDPP's former officials would have that the current leadership would not have. And therefore, in closing, I want to confirm and affirm that the NPA will fully participate in good faith in these proceedings, and at all points in time will participate within the scope of its mandate, the scope of this commission, and all lawful requirements that are required from it. And therefore, in closing, the NPA respectfully urges the commission to, while we accept the hardships that many families are experiencing, for the matters, while delicate, to be dealt with in a manner that requires accountability and in a manner that is fair to all parties. After all, we can appreciate investigations and decisions to prosecute or not to prosecute are not approached lackadaisically. They are approached with utmost care. Decisions that may seem to others as unfair need to be interrogated and put into their proper context. Such decisions to prosecute or not prosecute carry profound and lasting consequences, not only for victims and witnesses, but also for the accused persons and their families. In exercising that responsibility, it should be kept in mind that the National Prosecuting Authority acts within its constitutional mandate, which requires it to act without fear, favor, or prejudice. And that means there are times where particular matters cannot be brought to prosecution because of particular reasons. And it is in this commission that those reasons will then be dealt with. And we hope in dealing with those reasons, every party dealing with whether it's the prosecution policy, which we know has been at the heart of these allegations, what went into that prosecution policy, why was it actually implemented, what were the reasons. Therefore, what the NPA is saying, while we can accept that there has been delays, context is always going to be essential. Thank you.
Thank you, Ms. Mtloko, for that opening statement. We shall now receive the opening statement of Mr. Vani.
As the Commission pleases.
How many minutes are you going to require, Mr. Vani?
Madam Chair, our opening statement is a little more comprehensive, and we would seek around 45 minutes.
45 minutes. Yes, you may proceed, Mr. Vani.
Madam Chair, Commissioners, I appear with my learned friend Santha Pillay instructed by the Pro Bono Department of Weber Wenzel. Before I proceed, with the leave of the Commission, may I hand up copies of our opening statement for you to
Yes,
follow?
you may.
We will also email electronic versions to the Commission and the parties. So, Commissioners, our opening statement is made on behalf of the following families and individuals. Lucanio Bruce Matthews Kalata, representing the family of the late Ford Kalata, one of the Cradock 4 activists abducted and murdered near Port Elizabeth in 1985. Nombu Mshlali, representing the family of the late Skelo Mshlali, one of the Cradock 4. Cindy Elizabeth Mkonto, representing the family of the late Sparrow Mkonto, one of the Cradock 4. Allegria Inyoka, representing the family of the late Caiaphas Inyoka, murdered by the police in Davidton in 1987. Bonakela Jacobs, representing the family of the late Dickie Jacobs, who died in security detention in the Uppington prison in 1986. Fatima Harun Masut, representing the family of the late Imam Harun, tortured and killed in security detention in Cape Town in 1969. Trifina Makhatle, representing the 4 families of the COSAS 4, 3 of whom were murdered by the security branch in 1982 and 1 seriously injured who died in recent years. The COSAS 4 are Zandile Musi, Eustace Bimba Madikela, Chingo Matabane, Fanyan and Schlapo. Then we turn to Carl Andrew Weber, a survivor of the Highgate Hotel massacre in East London on 1st of May 1993. Lindeen Page, sister of the late Dion Harris, who was also killed in the Highgate Hotel massacre in May 93, as well as Neville Belling, a survivor of the Highgate Hotel massacre. Mbuso Koza, representing the family of Spoor Pewa, who was forcibly disappeared by the security branch near Winkelspruit in 1987. Tuli Kubeke, representing the family of Ntombi Priscilla Kubeka, who was also forcibly disappeared by the security branch in 1987 near Winkelspruit on the south coast of KwaZulu-Natal. Kim Turner, representing the family of the late Dr. Rick Turner, murdered at his Durban home in 1978. Dr. Turner died in the arms of Kim and her sister Jan while they were teenagers at the time. Sarah Bibi Lal, representing the family of the late Dr. Hussein Hafaji, tortured and murdered at Durban's Brighton Police Station in 1977. Zizakela Inestina Simelani, representing the family of the late Nokatula Simelani, who was abducted, tortured, and forcibly disappeared by the security branch in 1983. Stefan Mbuti Mabelani, representing the family of the late Matthews Mojo Mabelani, who died in security detention at Johannesburg's John Foster Square in 1977. Shlekani Edith Rikotso, representing the family of Ignatius Igi Mtubela, who was forcibly disappeared in 1987. Sidiso Mutasi, representing the family of the late Richard and Bosiswe Irene Mutasi, murdered by the police at their home in Hammanskraal in 1987. Madam Chair, our client Titso was only 3 years old at the time. He was left overnight with the bodies. That murder took place in his presence. Namali Rita Galela, representing the family of the late Twasile Champion Galela, one of the PEPCO 3 activists, abducted, tortured, and murdered by the security branch at Post Chalmers in 1985. Pumeza Mandisa Hashe, representing the family of the late Sipho Hashe, one of the PEPCO 3. Nkonto Godolozi, representing the family of the late Kwakwuli Godolozi, one of the PEPCO 3. Mugapi Solomon Tlapi, representing the family of Nicholas Ramuta Boyki Tlapi, who was forcibly disappeared in 1986. And lastly, we also represent the Foundation for Human Rights, a non-profit organization in pursuit of justice and the rule of law and acting in the public interest. We collectively refer to the survivors and family members as the families. Madam Chair, Commissioners, on 25 March 1965, Martin Luther King delivered a speech on the steps of the Alabama state capitol in Montgomery after leading 8,000 civil rights marches from Selma to the state capitol. Martin Luther King asked, "How long will justice be crucified and truth bear it?" He answered, "Not long, because the arc of the moral universe is long, but it bends towards justice." For the families, the arc of the moral universe has indeed been long, multiple decades long. They believe that in the post-apartheid order, the arc would bend firmly towards justice. Regrettably, for most of the families, the arc of the moral universe has been firmly deflected from justice. Most will never see justice done in their cases. It emerged over the years that the failure to pursue justice in their cases was no accident or oversight. It was not, as a senior ANC official claimed on an international TV show, a matter of the TRC cases simply falling through the cracks. In fact, various high-level interventions ensured that these cases were to be treated differently from other cases, other murders, other serious crimes. They were to be treated as second-class cases, not worthy of attention in the normal course. These interventions undermined, eroded, and ultimately stopped most of the TRC cases from proceeding at crucial times when suspects were alive and witnesses were available. The interference caused the families and their communities incalculable and irreversible harm and prejudice. They deserve to know how and why this happened. Madam Chair, they deserve nothing less than a reckoning. It is for this reason that the family spent more than 6 years asking President Ramaphosa for an inquiry, and when he ignored their pleas, they were forced to approach the High Court in January of 2025, seeking constitutional damages and an order compelling him to set up a commission. Only then did the President act, establishing this, the TRC Cases Commission of Inquiry. The families ask, with considerable justification, why did they have to go to court to get the President to act? Turning now to the betrayal. The families had to endure violence, murders and disappearances perpetrated against themselves and their loved ones during apartheid. In the post-apartheid era, they had to endure the denial of justice. This denial cut the deepest. It stands as a deep betrayal. The families are at their wits' end as to why successive post-apartheid governments turned their backs not only on them, but also on their loved ones who paid the ultimate price for South Africa's freedom and democracy. The sacrifices of the families and the long fight for justice have defined them and their life choices. They've spent decades searching for the truth and struggling to do justice to the lives of their loved ones, which were so brutally cut short. They've done so in the face of the intransigence of the post-apartheid state, which has misled them and treated them with contempt. In this regard, the Commission is expected to hear from Kanya Kalata, the son of Ford Kalata, one of the Cradock Four, and Tembi Simelane, the sister of Nokatula Simelane, who was abducted, tortured, and murdered by the security police. Supporting affidavits of 21 other family members providing their stories and their struggles have been supplied to the Commission. But for most of the families, it is too late. Their lifelong struggle for truth and accountability has come to naught. Suspects and witnesses have died, bringing an end to any prospect of prosecution in most of these cases. these cases can never be resurrected. The damage has been done. Most perpetrators have died without facing justice. We have attached to these submissions, this opening statement, a list of some 30 suspects in apartheid-era crimes who have died since the winding up of the TRC, some in recent years. We won't go through that list, but we invite you to study it. And family members have also passed on. These include Saroma Nyoka, mother of Caiphas Nyoka, murdered by the police in his bedroom in 1987. She died in June 2010. Yusuf Hafaji, brother of Dr. Hussein Hafaji, who died under security branch interrogation in 1977. Yusuf died in 2009. He led the attempts to investigate his brother's death and detention. Hussein's mother, Fatima, died in 2011. The son of champion Gelele, one of the Pepco 3, Tebogo, died in 1996. And another son, Lekhondo, died in 2011. On 29 September 2019, exactly 50 years after her late husband, Imam Harun, was buried, Galila Harun died at the age of 93. She did not see anyone punished for her husband's torture and death and detention. Philip Mabalani, father of Matthews Mabalani, who died in security police detention at John Vorster Square in 1977. The police claimed he jumped out of the 10th floor interrogation room of John Vorster Square. Philip died in May of 2018, while in August 2020, Lash Mabalani, Matthew's brother, passed away without reaching closure. James Tlapi, father of Boyki Tlapi, who was forcibly disappeared from security police detention, died in September 2020. On 28 June 2021, Zandasile Musi, the only survivor of the Kosos 4 entrapment killing, died without seeing justice. On 20th August 2020, Nyameka Goniwe, wife of Matthew Goniwe, passed away. Matthew's daughter, Nobuzwe, died on 22 July 2024 at the age of 49. They died before seeing justice done in Matthew's brutal murder. Neville Harris, father of Dion Harris, who was one of the 5 murdered during the Highgate Hotel massacre, died in July 2023 without closure. On 2nd June 2005, Lucy Mtubela, the mother of Iggy Mtubela, a former MK operative who disappeared in 1987 in the hands of the security branch, died. Iggy's brother Samuel died in January 2021. Madam Chair, there are many more examples. It is not surprising that apartheid-era perpetrators, witnesses and family members are rapidly dying off, given that most of the offences took place between the 1950s and 1980s. Most perpetrators were born between the 1930s and 1950s. They are typically in their 70s, 80s, or even older. It is a race against time, but we have seen little or no urgency on the part of the authorities, a situation which we would submit sadly prevails till today. Madam Chair, the cruel indifference of the post-apartheid state robbed the families of justice, peace, and closure. The damage done to the families and their communities is irreparable. They remain deeply scarred today. Turning to the compact with the nation, South Africa's groundbreaking transition required a limitation of the fundamental rights of the victims of gross human rights violations. But as we're all aware, this was justified by the pressing need to promote national unity and reconciliation and to cross the historic bridge between the past of a deeply divided society to a future founded on democracy, equality, and peaceful coexistence. The principles set out in the postscript to the interim constitution were reflected in the design of the TRC Act. Perpetrators of politically motivated crimes who made full disclosure were eligible for amnesty, which included immunity from criminal prosecution and civil law actions. Conversely, those perpetrators who were refused amnesty or who chose not to apply for amnesty were meant to face the consequences, namely criminal prosecution in appropriate cases. In requiring victims in the wider community to forgo their rights to justice under the rule of law, the state made an effective compact with the nation and with victims and the families in particular. This compact required the state to take all reasonable steps to prosecute deserving cases in respect of offenders who were not amnestied. The TRC's final report, released in March 2003, stressed that amnesty should not be seen as promoting impunity. The TRC highlighted the imperative need for a bold prosecution policy in cases not amnestied to avoid any suggestion of impunity or of South Africa's contravening its obligations in terms of international law. Most victims accepted the necessary and harsh compromises that had to be made to cross the historic bridge from apartheid to democracy. They did so on the basis that there would be a genuine follow-up of those offenders who spurned the process and those who were refused amnesty. Now, this part of South Africa's historic pledge has not been kept. Contrary to this obligation, in the aftermath of the TRC, the state chose ultimately to abandon its obligations by undermining or blocking the TRC cases. Over the years, families of apartheid-era victims conducted themselves with resilience and remarkable patience. They committed themselves to the historic compromises that were required to move from South Africa's oppressive past to a democratic future. They participated in the TRC process in good faith. This involved having to accept that perpetrators granted amnesty would not face prosecution or civil damages claims. There was a general expectation, founded on the constitutional obligations of the post-apartheid state, that the authorities would prosecute perpetrators who were not amnestied and provide victims with reparations. For this reason, most victims and survivors and family members did not sue the new South African state for the transgressions of the apartheid state. According to the TRC report, read with figures released by the Department of Justice, of the 7,112 persons who applied for amnesty relating to some 14,000 incidents, just over 5,000 were rejected on the papers, that is in chambers, for not meeting the basic requirements for amnesty, while the balance were referred to hearings before the Amnesty Committee. Some 849 of these applicants were granted amnesty, while approximately 358 applications were refused. Murders comprised the biggest category of the crimes for which amnesty was refused, notably some 189 cases, which involved at least 353 deaths. Now, the families did not expect the apartheid police to investigate themselves or other security services. In those days, Madam Chair, it's hardly worth mentioning that they acted entirely without restraint and without the slightest fear of having to face justice. Compliant investigating officers, prosecutors, and magistrates ensured that apartheid security forces enjoyed near total impunity. However, the families did expect the post-apartheid state to pursue justice, but a near blanket impunity for apartheid-era crimes was effectively extended into the post-apartheid era through the meddling by the state in these cases. Now let's turn to the apartheid-era violations. The Constitutional Court has held in the Basson matter that the practice of apartheid constituted a crime against humanity, and that South Africa is obliged to prosecute apartheid-era crimes against humanity and war crimes. There is ample evidence in the public domain substantiating the conclusion that South Africa's pre-1994 order amounted to an institutionalized regime of systematic oppression, and domination by the white racial group over the black racial group. Madam Chair, is the definition of the crime of apartheid in the Rome Statute, which has also been incorporated into South African law via our International Criminal Court Implementation Act. On this score, Madam Chair, we do have some small good news, because only last year, in the matter of State versus Mfalapizza and Rorich, the citation is at footnote 18. In that matter, the High Court dismissed objections raised by the two accused against the inclusion of 2 counts of crime against humanity, apartheid as a crime against humanity and murder as a crime against humanity. And the court in that matter upheld the inclusion of those charges in the indictment. So that is a significant step forward. I should add that that judgment is currently on appeal before the Supreme Court of Appeal. Now, the TRC found that very serious crimes were committed during the apartheid era. Its report found that the security branch of the apartheid state, as well as other security services, committed a host of gross violations of human rights, including extrajudicial killings, the desecration and mutilation of body parts, kidnappings and disappearances, torture, severe ill treatment, abuse and harassment, destruction of homes or offices through arson, bombings or sabotage, the manipulation of society by turning groups against each other, resulting in violent clashes, the creation and provision of support to hit squads for deployment against opponents of the government, and tens of thousands of anti-apartheid activists were detained without charge or trial, or acted against under security laws. The TRC concluded that the security forces were a law unto themselves. The vast majority of murders and crimes carried out by them were covered up. Thousands of political activists were tried, convicted, and punished. According to the very useful website South African History Online, some 1,300 political prisoners served time on Robben Island. The total number of political prisoners held at all prisons would run into several thousand, and virtually all prosecutions that were brought against those opposing apartheid. Madam Chair, let's turn to the burning question, the subject matter of this inquiry, the political interference. Now, on behalf of the families, we intend to demonstrate that systemic steps were taken by members of the executive to close down or impede the TRC cases from being taken forward. We will argue that but for these steps, it is highly probable that from 2003 onwards, several cases would have been investigated and some prosecuted. There were early attempts to secure justice for apartheid-era crimes in the 1990s, post-94. These were carried out in an ad hoc manner by different investigations. I'm not going to take the Commission through them. They are set out in the papers, and we have footnoted the references. But these cannot be referred to as the TRC cases, as they were pursued independently of the TRC around the same time of its operations. Notably, these cases, such as the prosecution of former Vlakplaas Commander Eugene de Kock, took place before steps were taken to close down the investigations. And if we turn to the question of delivery, in terms of post-TRC delivery, the record is dismal. The stark fact is not seriously disputed by anyone. Since the handover of the TRC cases to the NPA some 25 years ago, the record as at the filing of the Kalata papers in January 2025 amounted to 6 concluded reopened inquests that occurred between 2017 and 2025, or at least early 2025, 4 plea and sentence agreements, and these all occurred between 16 and 21 years ago, 2 concluded criminal trials, one some 18 years ago of Transkei police officials, and the other in 2023, resulting in the conviction and imprisonment of a gang member. In the Caiaphas and Yorka murder case, one accused entered a guilty plea and was convicted in November 2024 and sentenced in July 2025. There has been a development in the Nyoka case. In December last year, the Johannesburg High Court convicted 2 more apartheid-era police officers, Sergeant Engelbrecht and Sergeant Stander, while one other was acquitted. We have set out a more detailed account of this work, or the lack thereof, in the Kalata founding affidavit, which is before this commission. From the perspective of the families, this failure is largely due to institutional interventions on the part of the then executive. Now, in contrast to this view, the former members of the executive appear to be saying that the lapses are not of an institutional nature, but rather due to the failures of the prosecuting authority and the South African police services themselves. Or alternatively, they seem to be saying that the neglect visited on these cases can be attributed to individual prosecutors and police officers. We disagree with this contention, and it is one of the key questions that this commission will have to interrogate. And let's commence with what might have been the genesis of the interventions or the interference. And these were discussions between representatives of the old and new orders. Now, it appears that between approximately 1998 and 2003, there were meetings and interactions between police and military generals and senior ANC or government officials. And Madam Chair, if I may pause here, we find it astonishing that the current president, saw fit to limit the investigations of this commission to what transpired from 2003. That we would submit is perhaps a blunder that was done out of ignorance of the facts. But we would suggest that as a matter of necessity, the Commission has to investigate the context and the genesis of the interference, and so we would urge the Commission to interpret its mandate purposively and not literally. So where there are events and developments in earlier years that inform or directly linked to the interference that occurred from 2003 onwards, then we would emerge that by logical deduction, they must also be fully investigated. Because if you don't, you can hardly be placed into a proper position to address what took place from 2003. Now, the information at our disposal points to several prominent persons attending one or more of these meetings, which occurred between 1998 and 2003. So from the side of the old orders, it appears that attendees at these meetings included, from time to time, F.W. de Klerk, Magnus Malan, Constant Viljoen, former Police Commissioner Johan van der Merwe, Generals Jan Geldenhuys, Dirk Marais, Neil Knubel, amongst others. And from the side of the new order, attendees appear to include Thabo Mbeki, Jacob Zuma, as well as various security cluster cabinet ministers. Again, these are set out in the papers. Now, it appeared that the generals representing the former apartheid security apparatus were seeking protection against prosecution, either in the form of a general indemnity or other forms of protection. Now, news of these interactions emerged from interviews conducted by authors Ole Bubenza in 2006 and Michael Schmidt in 2019 and 2020. Extracts from their books have been supplied to the Commission, and both authors are expected to testify in the first sitting of the Commission's hearings. Before F.W. de Klerk died, his foundation, the F.W. de Klerk Foundation, on 5 July 2021, released an editorial titled "The NPA's Decision to Prosecute Apartheid-Era Crimes." The editorial referred to an informal agreement not to prosecute apartheid-era crimes. And I quote from that editorial: "Because of an informal agreement between the ANC leadership and former operatives of the pre-1994 government, the NPA suspended its prosecutions of apartheid-era crimes. This statement points to the fact that there was some kind of informal agreement, arrangement, or understanding in place between the old and new orders on the question of prosecutions. An overview of these interactions, as gleaned from the books by Bebenza and Schmidt, are set out in the papers provided. It appeared that there was consensus amongst all or most involved that something needed to be done to address the impending prosecutions. Now, a blanket amnesty was apparently rejected by the ANC government because of the constitutional implications, but it does appear that other options were explored, including the preparation of draft legislation for the creation of a new kind of special plea in criminal procedure based on the TRC's amnesty criteria. Now, this did not see the light of day, but its essential ideas emerged later in the prosecution policy amendments. So the generals were not awarded with a blanket amnesty or any type of immunity that they sought, but the scene was set for subsequent developments that occurred from 2003, and which largely, in our view, provided the outcome sought by the generals. Turning to the handover of cases from the TRC to the NPA. During the winding up of the TRC between October 98 and September 2000, lists of cases involving serious crimes where amnesty had been refused or not applied for were handed over to the NPA. The exact number of cases is not known, but the Priority Crimes Litigation Unit, which was ultimately charged with dealing with these cases, the PCLU, registered some 459 cases during 2003, and that is gleaned from the NPA annual report for that year. These different steps are set out in the Kalata affidavit. And Commissioners, we expect to hear from former TRC Commissioners Yasmin Suka and Dumisen Sebeza SC in this regard, as well as TRC staffer advocate Paddy Pryor. On the side of those receiving the list, we also expect to hear from former NDPP advocate Bulelani Nguka and Judge Vincent Saldana, the former head of the NPA's Human Rights Investigation Unit. I should say that we do have statements already from Advocate Paddy Pryor as well as Judge Vincent Saldana. Preliminary work on the TRC cases were commenced by the HRIU, which had been established by Nguka for this purpose, and then subsequently by the Special National Projects Unit, the SNPU, under Advocate Chris McAdam, and that was located in the Directorate of Special Operations, the DSO, also known as the Scorpions. In May 2003, Nguka decided that all TRC-related cases in which amnesty had not been granted were to be prioritized. They were ironically declared to be priority crimes in terms of the PCLU proclamation. The irony, of course, is given what transpired thereafter. According to Advocate Anton Ackerman SC, head of the PCLU, this resulted in more than 400 investigation dockets being transferred to the PCLU. Shortly thereafter, Ackerman and McAdam started to identify and prioritize cases for prosecution. However, before they could get going, outside interventions brought a halt to their plans. They could only proceed with a handful of matters in which investigations had been previously finalized. Now, turning to evidence pointing to interference. Madam Chair, there's too much to go through to include in an opening statement, so we'll confine ourselves to a high-level summary, but we have set out detailed accounts in the Kalata papers as well as many other affidavits we have already submitted. Now, the families have compiled evidence and information pointing to various steps that we submit resulted in the closing down of the TRC cases. In this regard, the Commission is expected to hear the testimony of former NDPP advocate Vusi Pakoli, advocates Ackerman and Chris McAdam, as well as advocate Silas Ramata, SC. Let's turn to the first significant step that put the writing on the wall for the TRC cases, and this was the refusal to provide the PCLU with investigation officers. And this was the first practical intervention, the refusal of both the DSO and the SAPS to assign investigating officers to the TRC cases in 2003. And this was notwithstanding much pleading and the strenuous attempts on the part of Ackerman and McAdam to secure investigators. The SAPS indicated that they would only investigate TRC cases if the President specifically instructed them to do so in writing. Such instruction was never forthcoming. And this state of affairs persisted until 2010, when an investigating officer was assigned to the TRC cases, but he made little or no progress. As a result, there were practically no investigations at a time when many suspects and witnesses were still alive and when evidence and leads were reasonably fresh. Let's now turn to another significant step, and that was the creation of the Amnesty Task Team, the ATT. This body was created by the Director General's Forum, the DG's Forum, in early 2004 to explore ways of accommodating perpetrators who were not amnestied. The ATT included representatives from the Department of Justice, National Intelligence Agency, SAPS, the NPA, and Department of Defense. It created an interdepartmental task team, which included a representative from the Office of the President, and it acted under the direct supervision of the Inter-Ministerial Committee. I should say that, astonishingly, the Ministerial Security Cluster Committee created a ministerial team devoted to the TRC cases. This was a subcommittee of the Justice, Crime Prevention and Security Cluster. It was called the Cabinet Committee on Post-TRC Matters. And one may ask, what is a cabinet doing when it sets up a committee to look at a certain class of cases that are meant to be prosecuted? Now, the Interdepartmental Committee was to consider the advisability of a prosecution in each case and make a recommendation to the DG's committee, who in turn would advise the NDPP. The ATT, in fact, prepared a draft indemnity bill. We haven't been able to lay our hands on that bill as yet, and we hope that this commission will be able to do so. And it made various other recommendations on the use of prosecutorial discretion and pardons to avoid prosecutions. It even explored ways of eliminating private prosecutions and civil litigation in respect of the TRC cases. The ATT recommended that all involved, including the NDPP, take the national interest into account when making decisions on the TRC cases. And I'm sure one can have an interesting debate on what was meant by the national interest. Let's turn to the moratorium on investigations and prosecutions. During 2003, an effective moratorium was placed on the pursuit of the TRC cases. And this moratorium came into effect more formally the following year in November 2004, after Justice Minister Bridget Mabandla instructed acting NDPP advocate Silas Ramata SC to suspend work on the TRC cases pending the issuing of guidelines for those matters. Now, this occurred after an attempt by Anton Ackerman and his team at the PCLU to execute arrest warrants against suspects in the attempted murder of the Reverend Frank Chikani. These attempts were blocked after steps were taken by the suspect's attorney, the late Jan Wagenaar, who unbelievably secured the intervention of the Ministry of Justice. The Ministry of Justice communicated with the NPA, with Ackerman himself, and then later the minister picked up the phone and spoke directly with the acting NDPP advocate Ramata. Now, Ramata, according to his statement, advised the minister that her plans encroached on prosecutorial decision-making and violated prosecutorial independence. Ramata holds the view that the imposition of the moratorium by the executive and the development of guidelines by members of the executive to deal with the TRC cases were unconstitutional and forms of political interference. Needless to say, victims, survivors, and families were not consulted before their cases were placed on ice. The application of the rule of law was effectively suspended at that time for the TRC cases. Let's now turn to the infamous amendments to the prosecution policy. The new guidelines were the amendments to the prosecution policy, which has featured before this commission already, and they were only issued in December 2005. The amendments, frankly put, were aimed at shielding apartheid-era perpetrators from prosecution. They inserted the TRC amnesty criteria as new grounds to decline to prosecute and added other novel reasons not to prosecute, such as the degree of indoctrination that an offender might have been subjected to and his commitment to reconciliation. Those might be grounds not to prosecute. Ackerman and McAdam objected to the new policy on the grounds that it was unconstitutional, but they were overruled. I should add that Advocate Ramate also expressed his objections. Tembi Simelane and the Craddock Four widows challenged the amendments in the High Court in 2007, and the amendments were struck down as unconstitutional in 2008. Judge Lachodi in that matter described the amendments as a recipe for conflict and absurdity. Let's turn, Madam Chair, to the point where the axe really fell on the TRC cases. Now, the issuing of the amendments at the end of 2005 did not clear the way for the TRC cases to go forward. Indeed, the clampdown only tightened. The PCLU was still denied investigators. And they made this known to the family of Nakatula Simelane, amongst others. While the then NDPP advocate Vusi Pikoli had cooperated with the executive on these various initiatives in good faith, he started to push back during 2006 when it became clear to him that powerful elements within government structures were determined to impose their will on his prosecutorial decisions. At a certain point in that year, the head of legal services in the police communicated with the NPA and basically said they could not proceed on any matter until they had received a recommendation from the DG's forum in respect of each and every TRC case. Later in 2006, Pikoli was summoned to a meeting which was convened at the home of Minister Zola Skweyiya, then Minister of Social Development, where other cabinet ministers were also present. They indicated their concern that prosecutions on the TRC cases could open the door to cases against the ANC. In February 2007, Minister Mabandla indicated to Pikoli in a letter that she was under the impression that the NPA would not go ahead with prosecutions of the TRC cases. Now, Commissioners, this caused an exasperated Pikoli to address a secret internal memorandum to the Minister in February 2007, in which he bluntly stated the following: "I have now reached a point where I honestly believe that there is improper interference with my work and that I am hindered and or obstructed from carrying out my functions on this particular matter. It would appear that there is a general expectation on the part of the Department of Justice and Constitutional Development, SAPS and NIA, that there will be no prosecutions and that I must play along. My conscience and oath of office that I took does not allow that." In May 2007, Pikoli and Ackerman appeared before the Justice Portfolio Committee in Parliament, where Pikoli advised the members that in relation to the TRC cases, there was, and I quote, "political intervention," and I quote again, "and the NPA was being held to ransom by the former generals." One would have thought that those kinds of comments before the Portfolio Committee would have set alarm bells ringing. The tipping point was probably the decision of Pikoli and Ackerman to proceed with the prosecution of former Law and Order Minister Adrian Vlok and former SAP Commissioner Johan van der Merwe and others in relation to the attempted murder of the Reverend Frank Chikane, which resulted in a plea and sentence agreement in August of 2007. Later in that same month, Pakoli was summoned to a meeting of the subcommittee of the Justice, Crime and Prevention Security Cabinet Committee. I referred to that Cabinet Committee earlier. And this meeting was attended by Cabinet Ministers and very senior officials. In relation to Pakoli's approach on the TRC cases, the late former police commissioner, Jackie Salebi, told him that the gloves are now off and that he was declaring war on Pakoli. On 23 September 2007, Pakoli was suspended from office by President Mbeki. Pakoli is of the view that his approach to the TRC cases contributed to this decision. And shortly thereafter, Ackerman was summoned to the office of Advocate Mokotedi Mshe, who was now acting NDPP. Mshe advised Ackerman that he was relieved of his duties in relation to the TRC cases with immediate effect. Commissioners, let's turn to the special dispensation on political pardons. Later in 2007, President Mbeki established the special dispensation on political pardons to accommodate those who had not applied for amnesty, as had been previously recommended by the Amnesty Task Team. And as with the prosecution policy amendments, this process was aimed at shielding perpetrators who had not applied for amnesty from prosecution. The process was held behind closed doors, and it also amounted to a rerun of the TRC's amnesty program. Civil society organizations obtained an urgent interdict in April 2009 restraining the president from issuing political pardons, and the Constitutional Court in the Albert matter struck down the political pardons process in 2010. Now, the TRC cases remain buried. From late 2007, following the eviction of Advocate Pakoli, the NPA was placed in compliant hands and the TRC cases remained buried for years. Even after considerable pressure, an investigator was appointed in 2010, but the cases still remain stuck. The dockets in cases such as that of Nokutula Simelane and the Craddock 4 went missing and had to be reconstructed. And typically when a docket goes missing, that is sometimes the sign of a cover-up. Now, the families would only be taken seriously again when Tembi Nkadimeng, as she was known at that time, today she's known as Tembi Simelane, applied to the High Court in 2015 for an order compelling the NPA to take a prosecutorial decision or refer the death of her sister to an inquest. And this ultimately resulted in an indictment being issued against 4 accused in 2016. But it took, Madam Chair, a substantive application to court to get the NPA to act. And Commissioners, the NPA have in fact admitted to the interference in various occasions. The NPA in the Rodriguez matter, this was the permanent stay litigation brought by Jean Rodriguez, who was charged with the murder of Ahmed Timol. In that, in 2019, that the organization had been subjected to interference in relation to the TRC cases. Advocate Chris McAdam compiled an affidavit for the NPA, and although it was held back for some months, it was eventually filed, and he attached a number of relevant and helpful documents to that affidavit. He concluded his statement with the following reference. He says, "These documents speak for themselves and go a long way in explaining why from 2003 the PCLU constantly struggled to have TRC cases investigated." In a supplementary affidavit, Advocate Turi Pretorius SC on behalf of the NPA stated, and I quote, "The first respondent does not deny that the executive branch of the state took what one can describe as political steps to manage the conduct of criminal investigations and possible prosecution of the perpetrators of the political murders, such as that of Mr. Timol. When regard is had to what the fourth respondent says in paragraph 84, The only conclusion to arrive is that the delay in prosecuting the applicant was not as a result of the first respondent's own doing or its malice. It was as a result of the political interference and the severe political constraints to which the first respondent was subjected. We note, however, that the NPA vehemently, in that matter, denied that it should be blamed for the lapses and that it did not act out of malice, but it was rather a victim of circumstance given the political pressure from the executive. And we would submit that rather shamefully, the NPA did not make reference to its constitutional and statutory obligation to act independently and not to tolerate any interference in its duty to prosecute without fear or favour. Commissioners, the NPA should have resisted the political interference. Now, the full court and the Supreme Court of Appeal in Rodriguez expressed their dismay at the political interference and called for a full investigation. The citations are on the footnote. Commissioners, the families will be submitting that the closing down of the TRC cases was not the result of a few bad eggs in the NPA and SEPS, but rather the result of a concerted institutional drive to close down and suppress those cases. Now, the families have made numerous calls for a commission of inquiry. Following the admissions by the NPA in Rodriguez and the full court calling for an investigation, in early 2019, 10 former commissioners of the TRC addressed a letter to the President calling upon him to appoint a commission of inquiry into the political interference. When the President was not moved to act, several families, including those of the Craddock Four, Ahmed Timol, Neil Laggett, and others, approached the State Capture Commission of Inquiry, also known as the Zonda Commission, with a request that that commission investigate the interference, as in their view, the NPA and SAPS had been captured by outside forces. The Zonda Commission did commence investigation, but regrettably was not able to complete its work on this matter before it closed. A call for a commission inquiry, as well as an apology, were also made in a letter to President Ramaphosa on 23 June 2019 by the families of Chief Albert Lutuli, Steve Biko, Ahmed Timol, Ashley Creel, and several others. The families followed up again a year later on 23 June 2020. Both letters were ignored. In March 2021, former TRC commissioners, together with 18 civil society organizations, again pressed President Ramaphosa for a decision on a commission of inquiry. The commissioners threatened litigation and concluded their letter with the following prescient quote from the late Chief Justice Arthur Chaskelson: "We need to remember that the first incursion into rights is often the most damaging, that once inroads are permitted, the will to resist subsequent incursions is lessened." Since the Minister of Justice at that time indicated that he was investigating the setting up of an inquiry, and the NPA had instituted its own internal inquiry, known as the Nsebeza inquiry, into the handling of the TRC cases, the litigation was held back. But when President Ramaphosa did not react positively, he was placed on terms again in July of 2024, and the litigation ultimately launched in January 2025, seeking an order compelling the President to establish a commission of inquiry into the political interference and a claim for constitutional damages on behalf of the families. The litigation ultimately forced the President's hand, and within a few weeks of the filing of the papers, he withdrew his opposition to the case and agreed to establish a commission, stating that he wished to engage in mediation with the families. Indeed, he said he didn't want to fight the families. He wanted closure for them. And for that reason, he and the other government respondents, except for the NPA, withdrew their notices of opposition, a move that was greatly welcomed by the families. Sadly, however, the conduct of the President and the government has been erratic and subsequently damaging to the families in the country, because when the families reached out to the President and his team seeking to mediate and to resolve this matter, as one should do, given the issues at stake and given the constitutional imperative of dealing with these matters, the President inexplicably changed his mind and through his team said, no, he will not mediate, he will not negotiate. And so the government entities then closed ranks and adopted what can only be described as a highly technical approach, which was aimed at delaying resolution of the matters. Not only that, the President unilaterally inserted the question of the family's claim for constitutional damages into the terms of reference of this commission, knowing full well that this body cannot determine rights and remedies. It can only offer advice, which the President is free to reject or ignore. I'll just wait for the phone call to end. Now, we have written to the Commission indicating that we feel that the proper place for the determination of rights and remedies in respect of the constitutional damages claim is with the High Court, and indeed that claim is presently before the High Court. And papers are being exchanged as we speak, and that litigation will be proceeding during the course of this year. The President then took the step of approaching the court to reinstate his opposition to the family's application, and he brought an application to stay the proceedings pending the outcome of this commission. That further delayed the litigation. In early October 2025, the application for a stay of proceedings was dismissed out of hand by the High Court, which noted, and I quote, that it is rather ironic that the government, who is the sole cause for the delay, wants this court to sanction yet a further indefinite delay without being able to point to any tangible benefit. Commissioners, if I may just deal briefly with the opening statement of my learned friend, Mr. Nell, for AfriForum. We take no issues with the submission by Mr. Nell that crimes experienced by all sides of the conflict should be treated equally and investigated and prosecuted. We agree with that contention. There should be no favoritism. There should be no decision based on any political affiliation. And unlike the apartheid era, when only one side was targeted, prosecutors in the new constitutional era must never be motivated in their decisions by political affiliation. And if Mr. Nell's clients are victims of serious and gross human rights violations, and if those investigations and prosecutions were suppressed, then those matters must also be addressed. Madam Chair, we are deeply concerned that former Presidents Jacob Zuma and Thabo Mbeki launched belated last-minute applications in December 2025 for the recusal of the chairperson. Moreover, only last week, Mr. Zuma launched an application before the High Court seeking to review the refusal of Judge Kempepe to recuse herself. And Mr. Mbeki has also indicated in writing that he will launch a similar application. Now, the families take the view that this 11th hour litigation is aimed at derailing the Commission's proceedings. They point out that both former presidents are under a moral obligation to disclose what they know about the subject matter of this inquiry. And the families call upon the former presidents to return to this inquiry. They owe it to the families of those who laid down their lives for a democratic South Africa to explain why they were denied justice, truth, and closure. In conclusion, Madam Chair, the families are satisfied that unlawful and improper institutional interventions stopped their cases from proceeding for extended periods. Indeed, 3 superior courts have already also come to this conclusion. I've mentioned the Rodriguez matter, the full court and the SCA, and then also in the Mbeki intervention application, that court came to a similar conclusion. The citation is in the footnote. However, while we know that interference did stop the cases or undermine them, the full reasons for that obstruction are not known. And the families want to know the actual reasons why they were denied justice. Also, the source of the interference remains unclear and opaque. It appears that arrangements or understandings may have been struck with individuals and entities outside of government to block the cases from proceeding. And the Commission has requested, please uncover the genesis of the interference. The full means by which the will of outsiders was imposed on institutions such as the NPA and the SAPS must be exposed. The families want to know how institutions with firm constitutional and statutory obligations to uphold justice and to act independently so easily abandon their duties in respect of the TRC cases. Perhaps more than any other class of cases, the suppression of the TRC cases has been almost total in its impact. Virtually all the cases were blocked for an extended period of time. Most of the cases cannot be resuscitated, as many perpetrators, witnesses, and family members have died in the intervening period. And we take note of the submissions of my learned friend for the NPA that certainly under the current tenure and perhaps over the last few years, that steps have been taken. And to the extent that they have been taken, they're greatly appreciated. But it is a little too late. It's too little and too late, because it's not going to save the bulk of the cases in which we no longer have perpetrators, we no longer have witnesses. Those cases are dead and buried. The damage has been done. The impact visited on the families, their communities, and on the fabric of society is incalculable. The harm done to the families and South Africa as a whole demands an expeditious, thorough, and credible inquiry into the machinations that resulted in such a massive denial of justice. The families of apartheid era victims deserve nothing less than a full, open, public, and transparent inquiry. This must include public hearings, the power to subpoena and compel the production of evidence, and the right of victims to be represented in the Commission, to lead evidence, and to put questions to witnesses as appropriate. Where individuals failed to cooperate with the Commission, and where public entities failed to produce needed documents, we request, Madam Chair, that they must be compelled through subpoena to appear before the Commission. From the perspective of the families, the post-TRC period has been one of the most shameful times in South Africa's history. The families have lost all faith in the institutions that were meant to uphold the rule of law. There is a critically important need to restore public confidence in these institutions. And Commissioners, this Commission can play a key role in beginning the process of restoring trust through a credible and robust investigation that leaves no stones unturned. That's our opening statement. Thank you, Madam Chair.
Thank you, Mr. Vani, for a comprehensive opening statement. We shall now call upon Judy Seidman. Is she here? Yes, Judy. Are you going to make an opening statement? Yes, you must come forward and be next to a microphone. Ms. Seidman, how long will your opening statement take? How long will your opening statement take?
I would think between 30 and 45 minutes.
Okay.
I'm Judy Seidman. I'm presenting on behalf of Kulamani Kalela Reparations Movement.
If you can raise
Can
your
you,
voice.
can you raise your voice or pull the
Yeah,
microphone closer to your mouth?
I'm Judy Seidman. I'm presenting on behalf of Kulamani Galela Reparations Movement. Kulamani Galela is a mass-based social movement comprised of and representing victims and survivors of apartheid crimes against humanity. Our movement first came into being in 1996 with the establishment of support groups around the country to assist victims and survivors telling their experiences of human rights violations to the TRC, what were the original groups called the Kulamani support groups. Many of our members today are actually come from that original source of people going to the TRC. In 2000, these support groups joined to form the NPO called Kulamani Support Group. 2 decades later, many of these victims and survivors and activists determined to launch the Kulamani Galela campaign. Kulamani Galela asserts that the post-TRC processes have clearly failed to fulfill constitutional promises of justice, redress, truth, and repair for victims and survivors. We call upon government to fulfill its long-standing promises to both meet with us as victims and provide those promised outcomes of justice, redress, and restoration of human rights and dignity. For the past several years, our members have protested government's failure to meet these commitments. In particular, members have risked life and well-being for over 2 years, holding an ongoing protest, occupying the space in front of the Constitutional Court, while our government continues repeatedly to ignore us, despite many, many, many efforts to engage with them and to ask them just to meet with us to approach these questions. So in this context, Kulamani Galela fully welcomes and expects to contribute to this Commission of Inquiry into what we consider failed TRC outcomes. So in terms of the Commission, our input refers to what we see as 2 key mandates.
Ms. Seidman, could you please speak up a bit louder?
Okay. In terms of this commission, our input refers to 2 key mandates. First, the commission will inquire into whether, why, and to what extent and by whom efforts or attempts were made to influence or pressure members of the SAPS and the NPA to stop investigating or prosecuting TRC cases, and whether government actors might be held accountable for such interference. Secondly, we feel the other key terms of reference that we need to input to is the one that says, quote, whether in terms of the law and fairness is the payment of any amount of constitutional damages to any person is appropriate, as this obviously speaks directly to our members. So first, let me talk about the question of stopping investigations and prosecutions of TRC cases after 2003. Firstly, I do want to say we very much appreciate, build upon the incredible work that has been done by the families at FHR. And I'm not going to try and repeat all of that in the introductory statement. I might mention it where it's particularly relevant. We do want to say that, to start with, it's important to recognize that the term TRC cases refers to all the cases that fall within the scope of the promotion of the National Unity and Reconciliation Act of 1995, the so-called TRC Act. The Act defines victims as, quote, persons who suffered harm in the form of physical or mental injury, emotional suffering, pecuniary loss, or substantial impairment to human rights. And it then includes people who supported such persons and suffered violations as a result, and of course the descendants, dependents, relatives, and descendants of such victims. The TRC cases further are limited to human rights violations that occurred between 1960 and 1994, and cases that were undertaken with a political motive. We hope, although we still have to discuss the details of this, we have literally hundreds of testimony from our members, from victims and survivors, about their efforts to give statements about violations that they experienced to the TRC as specific examples of these TRC cases. These TRC cases are examples taken from a number of different categories and sectors that we consider fall within the definition of the TRC cases. And just to mention some of them, cases that the TRC did not recognize as qualified gross human rights violations under the Act. These include cases where victims were unable to give statements to the TRC for a range of reasons, statements where victims were unable to provide sufficient evidence to prove that their testimony was correct while giving statements at the TRC. And we note that both the NPA and the Advocate Varney's statement point out the lack of evidence that was available for so many of these. But many people did go to the TRC and simply did not have the backup information other than their own word as having experienced it. There are also other statements that were submitted to the TRC that were rejected because they were felt that they did not fill the criteria of gross human rights violations made with a political motive. And we highlight here what the category of the rape cases, which the TRC determined, apparently, we are told, on the ground that they did not include rape as a political crime because it was personally motivated and that people were not ordered by their seniors to commit rape. Now, we all know from world experience and from South African experience that is not actually a description of many rape in political contexts. But the fact is that many, many women presented statements about rape to the TRC and were told they would not take the statements because they did not fit the political motive criteria. Violations that fall under these categories that were not handed over as defined cases to the state to investigate or prosecute. We note that the TRC Final Report, Volume 7, admits that it was unable to take forward many of the cases because of difficulties faced within the TRC, including lack of access by victims, lack of investigative capacity within the TRC, failure from many victims to give statements within the limited time frame of the TRC. The TRC itself, in its final recommendations, calls upon government to put in place a national discourse and other measures that would lead to follow-up on unheard cases. Specifically, the recommendations state, quote, that victims should not be re-victimized and that any amnesty should take into account their needs and their right to the truth and full disclosure and ultimate reparations. That's in Volume 7 of the final TRC report. Sorry. The third area that we want to speak to are cases that were heard by the TRC and that were passed on to the police and the NPA for further investigation and prosecution at various stages of the TRC process. And I think Advocate Varney has talked quite a lot about that. But what we want to say about these is that the list that they have presented as affidavits to this commission involve many of our members, and that these cases were not dealt with in the period after the closure of the TRC. So in this case, we feel we have a direct interest in this question of why these cases were closed down. and that it is critically important that victims' voices are heard in this, because one of the big problems that we find in the post-2003 period is that victims, with the exception of the cases that have been brought by FHR, victims' voices have been simply told, you don't even exist in terms of the TRC, in many, many cases. And we can actually provide examples of that, of being told by senior officials of government, you are not really victims, so go away, go home, and stop bothering us. Cases where amnesty was refused to applicants is another category. Again, has been discussed, and I'm not going to go over the figures, but over 7,000 people did apply for amnesty. The TRC denied amnesty to the figures I have of 5,392 perpetrators, mostly on the grounds that they didn't tell the whole truth. As a result of that failing to tell the truth, many of the victims whose cases would have been recognized had they told the truth, therefore have no proof that their cases were there. So there's a direct link, in our view, between the failure to prosecute perpetrators and the silencing of victims about their cases. And we'll come back to that. We do want to point out that there is major overlap between the categories we've just mentioned. People who are not qualified as victims of the TRC or do not appear before the TRC do appear as unnamed victims in some of the TRC files that we know were handed over to the NDPP and SAPS for investigation. And again, we really want to thank the incredible work done by the families and the Kalata applicants on this. Just as an example, one of the files handed over in 1999 is not actually a case. It's a file that covers, quote, East Rand train shootings from 1991 to 1993. It mentions 60 people killed, of which it mentions one name of a victim. Many of our members lost family members or were injured in those train shootings. Those cases were handed over. As far as we know, they were thrown out. Not all of those people did get to the TRC. Again, the chances of their ever bringing their cases into public once that was closed was gone, as far as they were concerned. There are also numerous cases, as I said, where perpetrators were refused amnesty but were neither investigated nor prosecuted. And these, again, involved many victims who were unable to access the TRC and therefore could not provide proof of the violations that they actually experienced. And proof, by the way, does not include being shot in both legs, and because you have to then get a hospital or a police statement that you were shot under such conditions, and those were simply not accessible to people who were shot under conditions in the early 1990s or late 80s. And we are told many of the hospital records have also been destroyed. We note that this commission is directed to inquire into refusal to investigate and prosecute TRC cases after 2003. The commission's evidence leaders have said earlier that this does not preclude introducing testimony of efforts prior to 2003 to stifle or bypass or refuse to investigate or prosecute cases. So historically, as Kulamani Galela, we think we need to emphasize two underlying arguments used during the TRC to refuse to accept victim stories as sufficient evidence of victim status. One was that Evidence was not required from victims, as perpetrators would tell all, and therefore there would be no need for further evidence to prove victim stories. That, as we know, just did not happen for most people. Secondly, victim stories were framed, and the TRC is quite explicit about this in its victim hearings, as giving, quote, a broad understanding of human rights violations, rather than either identifying each and every case of violation or in finding specific evidence to establish cases against perpetrators. Thus, the TRC was not given the powers to investigate. If somebody came with a story, the TRC, and they did not have the police, that the evidence that the police had done such a thing to them or whatever, the TRC simply did not have the powers to further investigate. We need to emphasize, however, while these problems hindered recognizing victims prior to 2003 and thus prevented and interfered with investigating and prosecuting perpetrators, the TRC's final recommendations both admitted to and proposed ways to correct these difficulties. Kulamani Galela therefore suggests that this commission needs to look at not the blockages within the TRC to recognizing victims, but the measures taken upon the closure of the TRC not to recognize those victims, despite the fact that their cases had not been properly made. Kulamani also plans to testify that the fundamental shift that occurred in terms of investigation and prosecution of perpetrators was introduced by a series of linked government decisions made in 2003 after the closure of the TRC. These were articulated and placed before the nation by then-President Thabo Mbeki in a speech to Parliament on the 15th of April, 2003. This speech, which explicitly claimed to chart the way forward for government action after the TRC was formally closed, puts forward a number of core alternative proposals to the TRC recommendations. These include, firstly, to only recognize as TRC victims those persons qualified by the TRC as victims. That is the so-called closed list. That if you did not get to the TRC or your story was not accepted or you did not have proof, you did not count as a victim. That became a formal regulation, a formal proposal of government in 2003. It had been put forward to the TRC and had much discussion, and in their final volume, they questioned it, in fact. But it was formalized in the April 15th speech by Thabo Mbeki. Secondly, to provide special pardons or special indemnity, however it was framed, to perpetrators who did not apply for or were not granted amnesty. And I think, again, Howard Varney has talked very in detail about how that process went forward. That was first mooted in the 15th of April speech. To cut back on reparations given to victims, only to qualified victims, to less than a quarter of the amount recommended by the TRC that they considered adequate and appropriate. So it went down from approximately 126 to 135,000 per person to 30,000 once off, finished. And again, only to people on the so-called closed list. And then to ensure that a number of other measures that were taken, these were also mentioned in the same speech, that also prevented further follow-up on TRC outcomes, such as introducing a wealth tax, seeking financial compensation from transnationals as a means to reclaim from those who had benefited from apartheid crimes. So all of those were put together in the same speech and presented to Parliament essentially as an alternative to the TRC recommendations in Volume 7, which we believe actually tries to rectify some of the problems that they had encountered. Hopefully we will, sorry. Technology is not cooperating. And I don't know why. Okay. So taken as a whole, the measures proposed in Thabo and Becky's 15th of April 2003 speech ensured that any evidence by victims that had not been placed before and accepted by the Human Rights Committee or was not revealed and confirmed by perpetrators seeking amnesty would not be accepted as an outcome of the TRC. It blocked other mechanisms that might provide ways to ensure that government could prosecute and hold to account apartheid-era perpetrators, including specifically the first proposal about a pardons process. In terms of testimony on this, we have actually collected literally hundreds of statements from our members about how this affected them personally. We would like to present possibly 8 or 9 or 10 of these as core examples to this commission to show what the impact was. We still have to negotiate as to what's feasible. We realize it is not the role of the commission to rehear the TRC or redecide the TRC, but rather this is to talk about how people were actually affected by this directly and how they were persistently not included. One of the points that's frequently made is that after those cases in their various forms were handed over to the NDPP and the SAPS to follow up, not a single case that we know of went back to the victims who were named and asked them for any input. It's just silence. So, and we feel, I should just add, that in the several cases, again, I think Howard Vonnie has mentioned them, where these have come before the courts have mentioned that not hearing victims on the issues of perpetrators has been one of the actual violations of constitutional rights. But this actually, to us, forms proof of this. We could also submit written testimony from our members, not for actual presentation, if that would be useful. We can discuss that. Okay, so secondly, the second area that we wanted, these were not accepted by government, starting with that speech on the 15th of April in 2003, and it didn't happen. The 2008 judgment in the Naktula Similani matter that Howard mentioned actually opposes the special pardons dispensation as essentially a backdoor blanket amnesty, and it ruled that the specific pardons process denies victims' rights, which consistently affirm that victims must be included in any individual pardon or amnesty decision. The court then ruled that failure of the special pardons dispensation to engage with victims' views and concerns was unconstitutional. Again, we can go into the details of this. We hope we will in giving full evidence later. We will also present as Kulamani Galele Reparations Movement to the Commission the mandated resolutions of our own members calling for constitutional damages for victims and survivors who have suffered now for 25 years since the closure of the TRC of the failure to provide promised justice, redress, and restoration of human rights and human dignity to apartheid's victims. Again, we can provide examples of individual testimony of the impact this has had on people's lives, and we need to discuss what is feasible within the context of the Commission, and so on. We do want to mention that, as well as the illness and death and living in poverty and everything else that many victims have have had to deal with since the closure of the TRC, with no way to ask for redress at all, or we were told there was no way. We have also, in the course of our demonstration at Concord, we have lost 9 members, living in very unhealthy and life-threatening conditions, including the court refusing to allow us to use toilets and water and so forth, on the grounds that they don't consider this a legal demonstration, despite the fact that we have informed the court and the presidency and so forth that we are doing this, and that we are, and they actually had said they would meet with us and then they wouldn't meet with us, so on and so on. I'm not going to all of that. I think I should just mention 2 of the people who died at Concord specifically. One of them, Mr. May from Cape Town, actually developed, he was in his early 80s, I think. He developed a form of asthma which affected his heart after sleeping rough outside Concord for, I think it was 6 weeks. We did get him to hospital, and eventually he was flown back to Cape Town, but he died at home. Another member, Tabo Shivangu, had essentially a stroke after spending a year and a half at Concord, and died there.
Sorry, I don't want to interfere, but will it help?
Sorry?
Will it help if you are those members who have passed on?
Yes.
To get their names, and if possible,
Yes, we intend to submit all of this information
Yes.
in detail.
Yes. Okay. Thank you.
So, sorry, my technical problems are giving me trouble again. I don't understand this. Okay, so I'm just about to finish then. So what we are asking from the Commission then is essentially a recognition that there are victims and survivors, that these victims and survivors have clear grounds to call for constitutional damages. And specifically, we are asking for damages for victims, survivors, and their families and descendants who were denied adequate and appropriate reparation and justice promised through the TRC process. And this was denied again after that decision in 2003. This denial has been enabled and enforced first by government's persistent refusal to follow up on investigations and prosecutions flagged by the TRC for further action, and secondly, by government's continual and ongoing refusal to take victims' perspectives into account in any of these issues, and actually blaming victims for the difficulties they face while calling for redress and reparation. And then secondly, we also call for constitutional damages for those victims who have risked their life and well-being attempting to bring these matters to government's attention, where government has repeatedly said they will meet with us, including in signed affidavits at various points, and then a month or 2 down the line say, well, we've decided not to, without giving us reasons. And it's been a very painful story. I think I'd just like to conclude by saying that we feel this commission offers for the first time in 25 years, an opportunity for these issues to be dealt with appropriately and properly by our constitutional democracy, which we feel we fought for, we're very proud of. It needs to be activated the way it's supposed to be activated. Our Constitution has laid down basic principles which we need to enforce. And we are very pleased and proud and to be able to present this in public and to this commission. Thank you.
Thank you, Ms. Seidman. I think this would be an appropriate time to adjourn for tea, and we'll reconvene at 11:15. Oh, no,
No.
at 11:20. We'll reconvene at 11:25.
Do the engines have a multi-plug? Sorry, is that me?
Yeah, it's you. Sorry. Kelvin. Kelvin. Can you please speak on the mic? I want to test with the lady on Teams.
Hello?
Unfortunately, right here I don't have a power supply, but I see these guys have a long one of my guys is on standby to assist you with power there. So if you are able to just send that Janus down there, he's gonna plug you in.
So these guys are lost. We're trying to charge the laptop. And they're saying if there's a multi-plug, then
Or then you unfortunately I don't have a power supply.
uh,
Okay, let me just sort out this Zoom Teams issue and then I'll try to find a multiply for you. Kelvin, please speak on the mic.
hello?
Yeah, I
Hello?
can hear you. I want to send you into the venue. Robin, please keep on speaking.
Hello? I'm here. Can you hear me?
Mr. Hethon will receive your opening statements.
Thank you, Madam Chair. Good morning to you and the
Yes,
commissioners.
bring your microphone closer to you.
Oh. Can you hear me better now?
No, barely.
Madam Chair, we prepared an opening statement in October. I have sent an opening statement, an amended and abridged opening statement to the Secretary this morning.
Yes, how long are you going to require for your opening statement, Mr. Hethon?
I think not much more than 10 minutes,
Thank you, Mr.
perhaps
Hethon.
15 at the outside.
Yes, you may proceed, sir.
Thank you. Yes, so my name, Commissioners, is Murray Hawthorne. I'm an attorney at the Legal Resources Centre in Johannesburg. I'm accompanied by my colleague, Shatira Hassim,
Yes.
who is co-author with me of the opening statements. The Legal Resources Centre acts for the family of the late Dulcie September. It takes its instructions from Dulcie September's nephew, eldest nephew, Michael Arendse, who resides in Cape Town. It is he who represents the family in its relationship with the Legal Resources Centre. In my October statement, I made it included a long section on the history of Dulcie September's activism. As interesting as it is, I will only start with her appointment as the ANC's chief representative to France, Switzerland, and Luxembourg at the end of 1983. She was stationed at the ANC office in Paris. Her time in Paris was marked by her fierce commitment to imposing strict sanctions on the apartheid regime and ensuring that countries stuck to them, making enemies both in government and those business interests in southern Africa. On March 29, 1988, between 9:45 and 10 a.m. in the morning, Dulcie September was shot five bullets in the head with a .22 caliber silenced rifle in the hallway as she was entering the ANC's offices in Paris. There were no witnesses, save for one resident of the building, a Mr. de Crepy, who heard footsteps running down the stairs after the shots were fired. I come to the relationship with the Legal Resources Centre. The LRC was initially approached in this matter by Jacqueline de Rennes, French anti-apartheid activist and former colleague of Dulcie September, towards the end of 2017, after she had heard former LRC Director Steve Karnowitz address a conference in Paris. During a visit by Michael Arendse, the eldest nephew of Dulcie, as I've said, and other family members in late March 2018 to attend events in Paris, France to commemorate the assassination, a meeting was held between family members and senior officials from the town of Arsuel, where September had lived, forgive my pronunciation, to explore ways to reopen the case in France and South Africa, and to get the two countries to cooperate in the investigation. It was after that that Arendse secured a meeting with Steve Karnowitz in April in Cape Town of 2018. The LRC directed a PIA request to the SA Embassy in France and to DIRCO. The response led to the disclosure of an archived box in South Africa retrieved by the LRC, but containing only documents relating to Dulcie September's life in South Africa before going into exile. The LRC search in June-July 2015 also led to the South African Historical Archives, specifically their Section 29 documents from the TRC and their Right to Truth Project findings, both of which had been classified for many years and had only recently come to the public eye through the tireless work of the South African History Archive. The LRC's check of the Section 29 records at the archive produced nothing of note concerning the assassination. The French investigation. The family did not ask the South African authorities to investigate Darcy's death, believing this obligation lay with the French authorities. However, the family did brief the LRC to conduct investigations in South Africa. As far back as 1992, the French authorities had closed their docket on the Darcy September murder after it was ruled by French Judge Claudine Foucault that there was no new evidence. In this regard, well, let me just carry on. The TRC investigation. The TRC investigated the matter of the murder of Darcy September. The TRC assigned the task to a seconded Swedish policeman, Jan Akka Kjellberg. Of particular note, we have taken a statement from Kjellberg. We have had several consultations with him and have made that statement available. It's an unsigned, it hasn't been sworn to yet. If needs be, it can, but I see from the rules that we don't need to have an affidavit sworn. But if we should do it, we will. That statement has been placed before the Commission on the 3rd of this month. In that statement, Kjellberg says the following. On 13 February 1998, during his time, of course, investigating the matter for the TRC, a meeting was held with Dr. Turi Pretorius in his office in Pretoria. Pretorius, of course, being a senior member of the NPA, a senior prosecutor of the NPA, who has been referred to in discussion this morning. So, concerning the investigation into the assassination of Darcy September in Paris on 29 March 1988, Pretorius disclosed the following information. This is Pretorius's information as recorded by Kjellberg. Based on intelligence received from an undisclosed source, Dr. Pretorius reported that the weapon employed in the assassination was allegedly sent from South Africa to the London embassy via diplomatic mail. The gun was handled by a representative of the National Intelligence Service of South Africa in London and subsequently collected by another NIS representative stationed at the South African embassy in Paris. This individual reportedly traveled by car from Paris to London to collect the weapon. Kjellberg notes, no detailed information was provided regarding the identities of those involved, the vehicles used, or the precise timing of the transfer. I would submit, though, that it appears that Dr. Pretorius knew much about the assassination, whilst he was at the time a senior NPA official. And it must have investigated it to some considerable degree. Therefore, we submit that the Commission ought to call Dr. Pretorius to these proceedings to testify what he knew about the Commission, what he knew about the murder, and to testify what he knows about the apparent closure of the investigation at that point. There's no evidence that we know of, that the family knows of any further investigation by the South African authorities, notwithstanding the knowledge which Dr. Pretorius had of the assassination, until 2022. So in fact, for 24 years, including the period from 2003 onwards, there was no investigation. Michael Arendse was informed by the Directorate for Priority Crime Investigation in November 2022. I've got 2002 in the document I sent to the Commission this morning. He was informed by the Directorate for Priority Crime Investigation in November 2002 that it had started to investigate the assassination. And that would, of course, be consistent with the obligations of the prosecuting authority to keep the victims informed of what is going on and to consult them about important decisions. And that also was referred to us this morning, that was discussed this morning. We do know that in October 2025, an application by the Director of Public Prosecutions Western Cape to invoke the Mutual Legal Assistance on Criminal Matters Treaty between South Africa and France in the September matter was granted. I have made that document and the associated documents available to the Commission. They were sent to the Commission. I cannot tell you the date, Madam Chair, but recently. This treaty, so the treaty must be read with the International Cooperation in Criminal Matters Act number 75 of 1996. This act commenced on 1st of January 1996. The treaty was ratified by Parliament on 11 November 2002, and it came into force on 1 March 2004 and published in the Government Gazette number 27371 on 18 March 2005. So the South African Prosecuting Authority has had at its disposal and use this treaty since, with effect from the 1st of March 2004. The first we hear of it being invoked is information given to Mr. Arendse last year that the application had been successful, and as I say, the order granted by the court has been made available to you. The question then arises, why has it taken South Africa until 2022 to begin to investigate the Dulcie September case, or at least to resume investigation of the Dulcie September case, after it would appear that Dr. Pretorius started that process and it must have stopped as far back as 1998. We believe that Dr. Pretorius can shed light on the answer to these questions. His answer can, we submit, assist this Commission find the answers required of it in terms of the terms of reference contained in the proclamation notice establishing the Commission. So too we submit that the documents which we have asked the Commission to call for in terms of paragraphs 1, 2, and 3 of our letter, of our email to the Secretary of the Commission, dated 3 February 2026, can help answer this question. I will just quickly run through what those documents are. We have requested the Commission to call from the records of the TRC for the report of Mr. Kelberg himself to the TRC on his investigative activities on its behalf on his trip to Paris in November 1997, where he was asked to go to Paris to investigate disconcerting evidence about who might have carried out the assassination. This background to this is set out, to what happened on that trip, is set out in the statement of Kelberg, which we made available to the Commission. It appears that Kelberg was accompanied by Mr. Wilson Magadla, who was not known to him. Certainly his professional capacity was not known to Mr. Kelberg. It appears that in fact he was not a member of the police. At one point, in discussions with a witness, Kelberg felt that the witness was about to divulge important information. He became excited, and Kelberg informed me that any good policeman will know that when a witness in an interrogation becomes excited, very often it's a prelude to important evidence being divulged. At that point, Mr. Magadla stopped the discussion and, in fact, brought them home without further ado, and stopped the investigation. Mr. Magadla is deceased. But Mr. Kelberg can testify to this episode, and therefore we ask also that this commission call from the records of the TRC for all reports on the activities of the late Mr. Wilson Magadla in connection with this trip to Paris, in particular the purpose of his making this trip, including whether he might have been assigned to rein in the investigation of Mr. Kelberg on this trip. We further ask Mr. Kelberg further gives evidence in his statement that he received a document from the TRC in Cape Town in which the people in whose possession it was were asking him to translate it because they believed it was in French. Mr. Kelberg assured them it was not in French. It was not, it was, they said it, it was in French. So that is the real point, that the statement was a French document. In fact, Kelberg said it was the first page of the docket of the French police into the investigation of this matter. It was not recognized as such, and therefore we also ask this commission to call from the records of the TRC the French police file on the murder of Dulcie September, which we believe to be in their possession, based on the statement of Mr. Kelberg. Kelberg is willing to give viva voce evidence to this commission, either in person or remotely. He is resident in Denmark. I would therefore stop on that note, Madam Chair. We ask this commission to arrange for the testimony. It can be done remotely, for Dr. Kelberg to give his testimony to this commission. And we also ask that in the light of that testimony, Dr. Pretorius be called to answer his questions of what he knows about the investigation of the Dulcie September murder, and what does he know about it having been stopped. It's probable that he was the investigating officer and he was in charge of this matter in the TRC, in the NPA at the time. He would surely then be the person who has knowledge of this matter and who should be questioned about what he knows, including in respect of the reasons why the investigation was stopped and in fact not resumed until the end of 2022. And that it is for those reasons that we also ask for the 3 documents which we believe are relevant and which we believe are in the possession of the TRC or the TRC archives. We would ask you to exercise your powers to obtain those, to call for those documents. Thank you.
Thank you, Mr. Hudson. We'll now call Mr. Lipile to come and present his opening statement. Mr. Lipile, how many minutes are you going to require for your opening statement?
Thank you, Madam Chair. 10 minutes will be fine for me.
10 minutes. I'll hold on to 10 minutes.
Thank you, Madam Chair. Honorable Chair of the Inquiry, Justice Kambembe, Honorable Commissioners, and fellow South Africans. I make this statement on behalf of Khulumani Support Group and its members and associates. In my role as chairperson of the National Steering Committee, Khulumani Support Group is the national membership organization of victims and survivors of apartheid atrocities and human rights violation. Khulumani members lived the history of struggle against apartheid, and those who have survived continue to carry the consequences of their violation. Khulumani Support was founded in 1995 at the time that the Parliament initiated debates about the proposal to host a Truth and Reconciliation Commission. Victims and survivors received no invitations to inform the debates. Subsequently, Ms. Sylvia Dlomojele and Ms. Katerina Mlangeni, as former members of the Detainees Parents Support Committee, initiated community dialogues, each attended by hundreds of survivors. The question they debate was the wisdom of participating when they had been excluded from the planning for the TRC from the start. The consensus was reached that participation was preferable because of the hope that this might contribute to an agenda of redress. That hope has seen almost no realization over these past years. This inquiry takes place 31 years since the debate of 1995 and is characterized by extraordinary limited terms of reference. The ambit of the inquiry reinforces for survivors the sense that the state has long turned its back on the majority of the people who paid with their lives to bring them to power. This perception is reinforced by the experience of extended delays in initiating the inquiry, attributed to the recurrent attempts of political connected to intervene to halt or to delay the important work of truth. The prolonged delays have meant hundreds have died without being heard, their voices now permanently silenced. Thousands have grown old without the recognition and weight the wounds from the past carried by ordinary people keeps growing, intensified by the levels of disrespect meted out by those in position of authority to the wounded, who carry deeply unsettled accounts about our history. Many who have gave the best years of their lives to the life of struggle for justice and dignity have voiced to us their sense that they wasted their lives in service to a vision that has faded beyond any recognition in the present. How did this become our current political reality? Tragically, South Africa in 2026 has not aligned itself with the African Union agenda of its declared decade of reparatory justice, 2026 to 2036. South Africa has, in contrast, continued to regard reparation as a mere symbolic demand rather than as a matter of justice, dignity, and development. The situation has been characterized by a complete lack of wholeheartedness in dealing with serious violation of apartheid, with the Truth and Reconciliation Commission that generated only 17,600 acknowledged victims of apartheid gross human rights violation to the present. Only these individuals with their children and grandchildren have been recognized as eligible for the limited reparatory measures that have emerged from the TRC implementation unit in the Department of Justice. It has been under the direction of the state that the TRC unit has been complicitly, in almost completely, ignoring the draft reparation of rehabilitation policy that Professor Hlengiwe Mkhize, in her capacity as the chair of the TRC committee on the reparation and rehabilitation, constructed from her direct engagement with survivor communities across the country. It became evident that the state had long decided that the people damaged by apartheid atrocities could be left to their own devices, abandoned by those it had brought to power, as if they were damaged goods, in a situation where Khulumani experience has been of a remarkable capacity of survivors to serve the nation as wounded healers. The state assumed the role of intimately promulgating ad hoc regulation on reparation to address only 17,600 victims and survivors out of 22,000 statements the TRC collected while it was active. It has been only these individuals who have received the TRR number that qualifies them for the limited reparation the state has approved. Around 100,000 proud struggle activists have received no repatriation support. They have been silenced and ignored. As they have aged, their suffering has deepened, while those in position of power turning a blind eye and a deaf ear to the calls and the appeals that Khulumani Support Group continues to receive every week. This suffering cannot be ignored at the cost of the well-being of our country, especially given that 2.6 billion remains in the Victims Reparation Fund, the President Fund, that Khulumani Support Group has had to continuously fight to protect for the purpose for which it was established through contributions of supportive donor government. Their goodwill has long dissipated. Through decades of survivors-led community-based work, Khulumani Support Group has documented more than 120,000 victim statements of apartheid-era gross human violations. These testimonies come from across Africa, rural and urban, women and children, families of the dead and disappeared, survivors of detention, torture, displacement, and political violence. The difference between 17,600 and more than 120,000 is not a technical discrepancy. It is the consequence of deliberate exclusion. It speaks loudly to the limits of original TRC process, which, with its restricted mandates, narrow definition of harm, short time frames, geographic barriers, fear, trauma, and poverty, many victims simply could not reach the commission in time or could not speak when speaking still carried danger. When TRC closed, victim did not end, but recognition did. For those excluded, non-recognition became the second injustice. Reparations were designed and delivered on the basis of partial victim population, leaving the majority of survivors outside the moral and material concern of democratic state. This inquiry, therefore, carries a profound responsibility, not merely to review past findings, but to confront the consequences of exclusion, not to treat victim recognition as close administrative exercise, but as continuing obligation rooted in dignity and justice. Khulumani presence here is not oppositional, it is evidential. Khulumani's database is not a symbolic, it is a record of lived harm. Khulumani leadership is not abstract. It is grounded in community that have waited far too long. We urge this inquiry to resist political pressure, procedural narrowing, and the temptation of premature closure. Truth cannot be managed for convenience. Reconciliation cannot be achieved through silence. Justice cannot be postponed without cost. This inquiry has an opportunity and a duty to affirm that the lives of those previously excluded still matter, that their suffering still counts, and that reparatory justice in South Africa remains possible. We appear before you not to reopen old wounds, but because these wounds were never healed. We call for all forms of political interference to be ended. The dishonoring politics of the state and the abusive politics Kulumani has had to face at the hands of former civil society partners. We will not be deterred in our sustained struggle for justice, fairness, and dignity. I thank you.
Thank you, Mr. Lipile. We shall now connect virtually to Ms. Robin Lister on behalf of AFORED.
I've got this. Nothing to hear. Oh.
Shall we take a short adjournment?
Hi, Robin.
Yes, we'll take a short adjournment. Yes. No, that's fine. Is Ms. Lister ready and available to present her opening statement?
I am. You
Yes.
hear me clearly?
How much time will you require, ma'am?
I say about 10, 15 minutes.
Thank you. You may proceed.
Thank you, Your Honour, Madam Chair, and hello to colleagues of the team for creating this inquiry and in this format that we have today. Our case is about the Rickbook air crash on the 13th of March, 1967. We echo all the sentiments for justice by our co-applicants. This statement is our submission to the South African Commission of Inquiry into the TRC cases. Focusing on the crash, it outlines the case as an example of stopped TRC cases detailing the crash in 1967, almost 60 years ago, early in the apartheid era. It gives previous findings of the official inquiry of our stopped submission and requests the submission to finally order investigation of this case to provide truth and justice as recommended by the current inquiry's mandate and to hold individuals responsible for these crimes accountable. There were 26 victims of this crash. Miss Audrey Rosenthal, Professor Johannes Brewer, Mr. Clifford Anderson, Mr. Vernon Edkins, Mr. Joseph Blackfield, Mr. Lothar Lau, Mr. Archibald Nixon, Mr. Rother, Mr. David West, Mr. Charles Williams, Miss Julie Venturas, Mr. Desmond Clear, Mr. Hans-Jürgen Dorn, Mr. Graham Evans, Mr. Douglas Lamb, Captain Lamb, Mr. Max Melmed, Mr. Leslie Scott Pearson, Mr. Victor Baden Power Wood, Mrs. Eden Verna Davina Wood, Mr. Norman Sasno, Captain Gordon Lepolsky, co-pilot Richard Treadworth, senior flight steward Bazane Holt, flight steward De Beer, air hostess Petra van der Poel, and Captain James Boyd. I give special thanks to all those who have worked over the years to help bring truth and justice for this case. It has been a very long and traumatic journey, but many have stayed the distance. In particular, Alan Elston, whose wisdom, advice and support have been ever present for decades to me, leading us to this point. I also pay tribute to all those who worked tirelessly but in vain to attain recognition at the original TRC in 1998, namely Helen Brown, Johannes Brewer Jr., and Martin Legasic. Sadly, most of the victims' immediate family members have since died, given up due to distrust of the system, or continued to suffer generational trauma, with memory of this trauma ever close to the surface. Our contention is that had this event not occurred, much of South Africa's apartheid atrocities may not have been part of our history. Like the Freedom Charter not being taught in my years at school, the crash of this plane has not been taught as an historic event for today's generation. We wish to change this. We wish to reveal the truth, to bring a stop to us being called conspiracy theorists. So, as an introduction, I'd like to highlight the background of this event. It occurred on the night of March the 13th, 1967. It involved a Viscount aircraft. The aircraft crashed into the sea approximately 1.5 to 2.5 miles offshore near Kaisers Beach, near East London, and with the loss of 25 people on board. The South African Airways flight, also known as the Rickbock crash, was a scheduled passenger flight from Port Elizabeth. All 25 passengers and crew on board were killed. Standard air crash investigation procedures with aviation experts were disregarded. The Minister of Transport, Mr. Schoeman, Mr. Van Rensburg, Deputy Minister of Transport, the Secretary of Transport then, and the Chief of Operations held tight control and gave conflicting reports of findings. Eyewitness accounts on land were disregarded for various reasons and discredited. The official findings of the inquiry, headed by Cecil Judge Marco, speculated without supporting evidence that the pilot of the plane suffered a heart attack while on approach, and the co-pilot was unable to regain control. There is still great contention about the ultimate cause of the crash. To date, the families do not believe the official report because they have so much evidence to prove questionable behavior and activity at the time of the crash. Moreover, they have been accused of being conspiracy theorists, while others propagate lies that have been told and mushroomed over the almost 60 years since the accident. This represents constant trauma, not only by the inability to lay one's dear family member to rest with dignity, but further human rights violations by accusation and disrespect. As a historical context, apartheid, as you know, was introduced in 1948. Professor Brewer, who was already in 1956 with the government, became an expert on the so-called anthropology and Bantu relations in the country. He served the government's advisory council, and in 1967, he was the acting chair of the Broederbond, but he had gained a reputation as a so-called verlichter, an enlightened person, and was said to be steering the Prime Minister Verwoerd away from the current then apartheid practices. He was beginning to doubt the future of white rule in the country. While he was a staunch supporter of the concept of separate development, he preferred to call it separate freedoms and never hesitated to criticize the government if he thought it was necessary. He wrote the speech for Prime Minister Verwoerd that Prime Minister Verwoerd was due to deliver before he was assassinated. His family believed Verwoerd was killed to prevent him making that speech. He attended Verwoerd's memorial service, telling his sister, "I'm the next one." This was in 1966. Premier John Foster, who had been in office for about 6 months after the assassination of Verwoerd, and the foreign minister at the time, Dr. Helg Miller, approached Brewer to take up an unprecedented post as a roving ambassador to African states. Professor Brewer was on his way to discuss this post with Foster after the crash. Surprisingly, this post never eventuated. Another passenger on board was an American ANC activist who was considered a target on the plane. The late Martin Legasek. had recruited her to work for the International Defence and Aid Fund, which provided financial lifeline for relatives of the ANC. Her duties were to have meetings, clandestine meetings, to find out contacts of people who needed money. A former East London mayor and a Partek security officer at the time, Donald Card, said that her briefcase was carrying an information of great interest. I was a child at the time of 12, and all I remember was the talk of finding this briefcase. Sorry. So we had questionable incidents in 1967. Talk about the location. Straight away, they said that the plane was found and then it was denied. And soon after the crash, they impounded the radio telephone tapes indicating that the pilot knew exactly where he was. We were told there were no bodies. And then there was a report of 21 bodies. Many families were called to identify their loved ones, and then they were told, sorry, there's a mistake. A body was washed ashore 3 weeks after the crash. It was identified as being from the crash, and a post-mortem was conducted on this poor body that was a headless torso. This body was buried in an unmarked grave. No families were informed. Only in 1998, after the South African Aviation Archives documents were discovered by the families, did they identify this post-mortem, and were they able to match up and identify it. Further 5 weeks later, a naked body with a decomposed face was washed up at Queensbury Bay. This body was suspected to be from the Rietbok. It was claimed by the police again, reportedly taken to the mortuary but for a post-mortem, but no record exists. Apparently, this body of a white male was buried in Duncan Village, a black cemetery, which never happened at that time. Finally, only recently we discovered that a fishing boat skipper, Joe Neff, related his discovery while fishing of a skeleton floating above his nets. He radioed the station. He was asked to bring the body in to the harbour, which he did, and he arrived in total darkness. It was all to be hush-hush. This body was sent off to Cape Town for forensic identification, and he later found out it was apparently the body of an Englishman, a 23-year-old Englishman, and my goodness, my body went cold when I realised who it was. At no time were any of the families notified of these discoveries. This is not normal conduct. The families were treated like enemies of the state. Normal process is to have the airlines have an investigator. South African Airways sent their team of investigators straight away to East London. The chief investigator, James Boyd, had arrived, and to his surprise, their team was given observer status. And at the end of the week, they were told that they could go home. He called his wife to say, I'm on my way home, but there are shady things going on. The next morning, he was found deceased in his hotel room. His body was not admitted to the mortuary, was sent to a Gauteng cemetery where his body was cremated before identified by his loved ones and before they were notified of his death. I got to speak to his son before his son passed, and his whole life had agonized about his father's death because the urn they received had black, damp stuff in it, not like a normal ash. And according to Dad's request, it was scattered, so they never got to do forensic testing. There was disappearing evidence. In the official report, evidence of a diving team and the control tower, many things that were not included in the official document. So it comes to the TRC Commission in 1998. Many of the families formed a group called AFORA, the Association Families of the Rickbook Tragedy. It was headed by Helen Brown, who did an immense amount of work, and still groping in the dark. Submissions were made to the TRC, but the families were referred to the civil aviation. They sent the submissions to Bishop Tutu, and to their horror, they never got any reply. They only found out via a radio interview that they were not included. We have found, so despite all this evidence, no reason was given for the failure to investigate. They did suspect the involvement of the Bureau of State Security. There has been much new information since 1998. We have official documents from the government proving that there were 21 bodies. We have many other documents proving utter secrecy. And our feeling, I won't bore you with all of the much information that has been revealed, but we have a request for a full investigation to first of all prove that this was not normal, it was not an accident, and to prove as much as possible. Obviously, many of the people are no longer with us, many of the family members have passed, but the generations continue. We wish to have a correction of history. So, in the absence of definitive resolution regarding the cause of the crash, there are suspicions, but I do not include anything without proof. The circumstances of this crash have led to much speculation. The Rickbook air crash is a stark reminder of the need for a comprehensive and transparent process to address all stopped TRC cases. We urge the Commission to prioritise this case to ensure the truth is revealed and that all victims receive the justice they deserve. Time is the enemy of those involved in this case, which occurred so long ago. We are keen to make use of the scant living witnesses. In conclusion, I make a solemn plea to Your Honour that you use your powers to protect our human rights and that of the victims by granting a heritage status to this crash site and the unmarked graves, which are currently the subject of social and commercial activity that we have begged to not go ahead. I thank you for your time, and I look forward to the outcome of this inquiry.
Thank you, Ms. Lichter.
Thank you.
Are we ready to receive the virtual opening statement of Mr. Ganda?
Not yet.
We'll take a short adjournment. Oh, he's not there. Okay. In that case, we'll receive the opening statement of Mr. Siminya.
Chairperson and Commissioners, as evidence leaders, we find it unwise Chairperson and Commissioners, as evidence leaders, we find it a little unwise to do an opening statement, particularly because there are crucial witnesses that this commission directs must be heard. We must obtain their statements, and we must accordingly then make a coherent strategy around these matters. But we, however, think it useful that we have some introductory remarks about the difficulties associated with the conduct of the work of the Commission. And I start by reminding all of us that this Commission was proclaimed and published 29 May of last year. That's a period, now that we're sitting today, longer than the original lifespan of the Commission and its work. Now, I just want to give us context. The work of the Commission is intended to cover, and I paraphrase, any interference with the prosecution and or investigation of TRC cases. And I hazard a guess that of the 7,000 odd applications for amnesty that served before the TRC, it is only 5,000 of which were refused. And I hazard a guess again that the Kalata group may prove to be a tip of the iceberg, because we have to factor those people whose number we don't know, who never even bothered to apply for amnesty. We must see why it is that those cases have to date not been investigated. And as the terms of reference tell us, and I propose to read the relevant part, the Commission is appointed to investigate matters of public and national interest concerning allegations regarding efforts or attempts having been made to stop the investigation or prosecution of the TRC cases. The Commission must, in relation to the period since 2003, inquire into, make findings, report on, and make recommendations concerning the following: guided by the Constitution, relevant legislation, policies, and guidelines. 1.1, whether, why, and to what extent, and by whom, efforts or attempts were made to influence or pressure members of the South African Police Service or the National Prosecuting Authority to stop investigating or prosecuting TRC cases. Now, we're making this point with deep frustration, because you would have expected that entities, particularly the state entities, and particularly the South African Police Service, and particularly the National Prosecuting Authority, would have been alive to this work, alive to the relevance why they are mentioned eo nomine, specifically rather, in the terms of reference themselves. They would not have had to wait for anything. But what we did, we also used the rules of this commission, in particular Rule 3.1, which I will also paraphrase, which places the responsibility on the evidence leader
to collate and place evidence before this commission. That is our primary function unless directed differently by the chair or the policy itself points differently. Now, in the discharge of our attempts at doing this work, we issued out a request for information which covered a whole plethora of individuals, from the 2 former presidents, from some members of the NPA, all the commissioners of the police since 2003 to date. And it is disheartening and disconcerting that as we see today, we have not received one statement from the South African Police Service, not one, of all the commissioners that have occupied various periods during the 2003 to date, not one single statement. I am now given a document dated the 9th of February 2026, which I'm advised we received yesterday, only yesterday. It too does not give me statements. It promises that I will have statements of few of those indicated persons by the 20th. This is hardly helpful. Now, if we consider that at the very least, state actors would have been the first people to assist the work of the commission, on the contrary, that's not happening. Now, we also issued what we call Rule 3.3 notices. By that, again, I'm rephrasing, by that it's an obligation on the commission that if there is somebody implicated in a statement of witnesses such as we have heard from the Kalata group, the duty we have is to bring it to their attention and to say, look, we are giving you excerpts of statement, but we'll give you statements, but we will identify excerpts of those statements which make reference to you and which implicate you. Now, Trust, Chair and Commissioners, of the RFI's request for information, we only received responses of 20% of those issued. We also issued 3.3 statements. This is the one where we invite the implicated persons to respond. Only 10% of those have been responded to. Now we're talking about people who occupied critical government positions, from the presidents, the ministers, the NPA, the chairpersons of the Portfolio Committee on Justice. No response at all. And we are saying it is disconcerting because you would have expected them, in particular, to be upfront and helpful. Now, we are mindful of the powers that the Commission has, in particular under Rule 3. We can go to Rule 310. It says the chair has the power to call for this evidence. We have been slow because of a whole number of complications to have to issue out documents of compulsion. We have also under the regulations the power to exercise in compelling that information to come forward. No less, we have the powers under the Commissions Act, that of subpoena and compelling witnesses to come and appear before this commission. But the rhetorical question asked is, why do you have to compel such senior state officials to help? It is not happening. Now, Chair and Commissioners, given the limited life of the Commission, we know We are constrained to do what we must do within a time frame whilst the commission is standing and alive. But for the extension of the first life of the commission, we would not be sitting today. And I harbor a suspicion we might just get to the end of the second half of this commission without discharging our responsibilities. And it would be in part because state actors don't want to help. This is at least from the distance from where I'm reading the scenario. It did not help also with our time management that we had to consider 2 recusal applications that virtually rendered the first term of this commission's hearings redundant. We were left with nothing, and now
Is it two? Is it 2 recusal?
2 recusal applications.
3.
2. Yes, it was my recusal
Yourself
and that
then-
and that of the
and
chairperson.
then the 2 presidents. Okay, doesn't matter.
Okay, yes. That consumed a considerable amount of time for the work of the commission to commence. When we were about to commence the November of last, then they started these applications. Now, we are being threatened that the 2 presidents will be bringing an application for review.
You have not been threatened. There has been one filed.
With another threat to follow, as I
Yes.
understand, but Chair, you're correct. Already we have been served with an application for the review of the chairperson's ruling in relation to her recusal as a chair. But all I'm saying about that is that is also in the wind a possibility for the work of the commission to be delayed. I don't want to anticipate how the other review application will look like. We have considered what this one that is filed is saying, and for that reason, we are minded to proceed with the work of the commission until such time and unless such time a court of law tells us we cannot. So we were having in mind the lineup of witnesses that would commence beyond these opening statements, and I would have to announce a little adjustment to that timetable. We were indicated to start with at least 4 witnesses of the Kalata group, with Mr. Lucanio Kalata being the first of those to come. Logistics are now suggesting differently, particularly with the work he does and the fact that we've got the State of the Nation address tomorrow. So the thinking is to try and bring Madam Simelani first, but even that seems to be okay, but cannot happen this afternoon. So, Chair, I'm highlighting that we are going to be forced to use powers of compulsion to obtain the necessary material to enable us to discharge our function.
Yes.
Yes, Chair.
Thank you, Mr. Simina. Mr. Vani, may I please come to you with regard to the sequence of the witnesses you wish to lead?
Yes.
Am I correct that Ms. Simelane will be the first to start?
Yes, Madam Chair. We originally had proposed starting with Mr. Lucanio Kalata, and he was scheduled for Friday. But given that the opening statements are now concluded, we asked whether he might be available tomorrow. But because he's a senior journalist with a broadcaster, he's tied up with the SONA address tomorrow. So he's requested to remain on schedule for Friday. I have spoken with Minister Simelane. and she has agreed to make herself available tomorrow morning. Unfortunately, she's not in Johannesburg today.
Yes. So tomorrow at 9 o'clock we can start with Mr. Simelane.
Miss.
As the Commission pleases.
Yes. And Mr. Kalata will then follow on Friday.
That's correct, Madam Chair.
And from there, where do we go?
We have supplied the evidence leaders with a very rough draft schedule. If my memory serves me correctly, then on Monday we can commence with Yasmin Suka, a former TRC commissioner, followed by Dumisa Insabeza. We have been in discussions with Mr. Insabeza, and he might request the Commission for permission to testify remotely, just depending on his condition, and we will advise the Commission in due course.
Yes, you'll make the necessary application in due course.
Indeed. There are further witnesses. I don't know if you wish me to take the Commission through them, but we have supplied a rough schedule to the evidence leaders.
Yes.
Chair and Commissioners, of course we are trying to keep this a little fluid because we are mindful that the Chair, in terms of Rule 11, has the power to change the sequence if so minded and good cause exists for it. But for now, this is the business of the day, Chair.
Thank you. Thank you, Mr. Vani.
As the Commission pleases.
Yes. We have come to the end of the proceedings in respect of the opening statements. We'll adjourn for the day and reconvene tomorrow at 9 o'clock.
As the Commission pleases.